There he is. He's coming.
Mr. Gross and his ghostly.
Yeah, his floating head.
Weird. Good morning, everyone.
Good morning.
Morning.
If you'll move up just a little bit, it'll focus on you instead. Well, no, that's too much.
Ms. Seibert, I'll wait. We still have a minute or two, but make sure I'll confirm with you that you're ready before we begin.
Thank you. I appreciate it.
And Jackie, was Jenny going to join us too?
That's what I was just saying. Where did Ginny go?
Here.
Not, yeah, our Ginny.
Oh,
Ginny
yeah.
from BODA. Yeah.
She was here.
She was.
Council, if we could just beg your indulgence 1 minute. I know it's at 9. I just want to make sure we have Ms. Hutchins. Any luck, Ms. Truitt?
Not yet. I sent her a message. Matt, did you, you're muted, Matt.
I think he's trying to
Here, she's trying to get in now. Sorry.
Great.
There she is.
Perfect. Ms. Seibert, whenever you're ready.
I'm ready.
Good morning. It is 9:02 a.m. on October 23rd, 2020, and today's proceedings before the Board of Disciplinary Appeals are called to order. As you know, the COVID-19 pandemic has made many adjustments to our proceedings, and the Supreme Court has issued emergency orders that require parties to participate remotely in these proceedings whenever possible. In accordance with those orders and in compliance with the state, local, and federal guidelines to social distancing and group size and restrictions, the Board of Disciplinary Appeals will hear today's cases through remote connection. You've all been sent instructions. They're also posted on the board site. Ms. Truitt will also post a phone number in the chat should there be any issues with disconnection, including myself. There's some construction in our building and our internet keeps going in and out. And if so, I know that Ms. Hinson will quickly pick up and do not wait for me if I end up getting disconnected. But if you need the number, in addition to the chat, it's 737-704-8039 to call. And as anything, if there's ever a disconnection with a party speaking or a counsel speaking, we will pause proceedings until that's reestablished. At this point, I'd like to introduce our board. And I know it's a very large number of squares. We've done our best to have a background to signify, as well as including our names. My computer is ancient and doesn't allow me to have the fancy background, so I apologize. I am the chair, David Gonzalez from Austin. I'd like to introduce the vice chair, Ms. Kelly Hinson from Dallas. If you could raise your hand just so we could see everyone. Perfect. Mike Mills from McAllen. Mike Gregory from Denton. Mike Gross from San Antonio. Nancy Stone from Amarillo. Jessica Barger from Houston. Guy Choate from San Angelo. Joe Cleveland from Fort Worth. Rudy Matire from Pflugerville/Austin. Bill Ogden from Houston. And Cindy Tisdale from Granbury. The board has instructed parties and counsel to submit electronic documents of any potential exhibits. We've received some of those exhibits electronically. You still must offer exhibits into evidence for purposes of this hearing, and the chair at that point needs to make a ruling on those exhibits to make them part of the record. So even though you've sent them to us previously, please make sure you're still introducing those this morning. If there's an exhibit that you hadn't pre-submitted and we haven't seen before, please just ask for leave of the court so we can have a chance to review it before offering it. If you need to display an exhibit that you have admitted, just ask Ms. Truitt for permission to share screen and she'll give you that permission so we can be able to display it for the board. Counsel, I don't know if there's any witnesses in this room. If so, I'll ask that you ensure compliance with the rule. We're invoking the rule for our virtual courtroom, and witnesses will be permitted in the Zoom meeting during their testimony. But otherwise, when they're in the waiting room, the rule applies. Please make sure there's no chat or any other conversations that are in violation of that rule. We have a court reporter present, and she will make an official proceeding and a record of today's cases. So any other recordings pursuant to the Supreme Court order are thereby prohibited. I'm going to call through this morning's docket just to be able to take announcements and time estimates. The first matter is a compulsory discipline matter involving a motion for entry of final judgment, In re Perry Cortese, BODA cause number 62036. My understanding is that has been continued until January of 2021 from the board's order yesterday. The second matter is In re Cassidy Teeter, BODA cause number 64721. Is the commission ready?
Yes, Jenny Kim for the commission, we're ready.
And how much time do you need?
I'd say approximately 5 to 7 minutes.
And is the respondent or someone representing the respondent present? Ms. Truitt, if you could just monitor to see at some point if someone's trying to get in or receive any contact. I don't believe we've heard any response or an answer has been filed. The last matter we have on our docket is a matter of a revocation of probation in reward BB Davison, BODA cause number 64755. Is the commission ready?
We're ready. Jenny Kim for the commission, we're ready.
And how much time do you estimate?
Maybe half an hour or so.
And do you have any witnesses?
Yes, I do. We have Heather White from our office.
Okay. And is she currently in the main room or is she in a breakout room or not logged in yet?
I believe she's in the waiting room.
Okay. Respondent, can you give me Mr. Davison, do you have a time estimate?
I think 30 minutes would probably be sufficient.
And will you have any witnesses?
No, Your Honor.
Okay. Any other cases I've missed that should be on the docket? If you were here for a case that we did not call, please let me know. All right, that completes our docket call. Mr. Davison, for purposes of just expediting, I'm going to call the cases in the order. And so I might ask for you to wait just for one moment for 5 minutes while we handle the first case on our docket. Okay?
Yes, sir. Yes, Your Honor.
I will call the case of In re Cassidy Teeter, BODA cause number 64721. And at this time, we're moving any non-participants into the waiting room, so only the parties and the counsel for the case will remain. Ms. Kim, yesterday during our meeting, the board had discussed when there's a default on matters of reciprocal discipline, that perhaps the the easiest thing for us, or we know in the past, sometimes people can read the whole petition. We would ask if you could focus on the proof of service, the discipline in the foreign jurisdiction, and what the equivalent discipline in Texas you're seeking. We've received your pleadings, but that would be most helpful to us if it's possible.
Yes, Your Honor. Mr. Davidson is still present with us, and I'm not sure. Mr. Davison is still present with us, and I wasn't sure if he was going to sit in.
Thank you so much. Ms. Truitt, is there a way to be able to?
I can leave the room.
No, there should be a breakout room that we can be
Yeah,
able to.
I'll make a breakout room. Just give me a second. You might have to click on something, Mr. Davidson.
Is it the one that's there's a leave meeting I see? And is that the one you're thinking?
No,
Order actions.
what did it look like when everyone else was moved to the waiting room? I'm
They
not
just
sure.
disappeared. Oh,
The
sorry.
very bottom, in the middle and the very bottom on the right-hand side, it had breakout room
Ms. Seibert, we can be off the
on
record.
the bottom of the screen.
Off the record at 9:11 a.m.
No, what did it look like when everyone else was moved to the waiting room?
They just disappeared. I think if I just leave and then come back in 5 minutes, it'll keep me in a holding room. It won't automatically pop me in. And then maybe you can just put me in when you guys are ready.
I think if you leave, you're going to have to call back in and use that link.
Right. Yeah. And then it'll just hold me in a room until you guys readmit me.
I think you're right.
Okay.
Right.
So I'll just go ahead and do that and call back in about 5 or 10.
Thank you, sir.
Yes, sir.
Thank you, Mr. Davison.
Thank you.
You ready to go back on?
Back on the record, please.
Okay, back on the record at 9:11 a.m.
And we've called the case of Henry Cassidy Theater. The commission petitioner, you may proceed.
Jenny Kim for the commission. May it please the board. This is a reciprocal disciplinary action brought pursuant to Part 9 of the Texas Rules of Disciplinary Procedure based on respondents' professional misconduct and disbarment in Tennessee and Kentucky. The petition for reciprocal discipline was filed with the Board of Disciplinary Appeals on September 9th, 2020. The order to show cause was signed on September 15th, 2020, requiring the respondent to show cause within 30 days of the order why identical discipline should not be imposed. Respondent was personally served with the petition and the order to show cause on September 23rd, 2020 by Terrence Froson, a private process server. The original proof of service has been on file with the board since October 9th, 2020. On or about January 27th of 2020, an order of enforcement was entered in the Supreme Court of Tennessee at Nashville in a matter styled In Re Cassidy Teeter, an attorney licensed to practice law in Kentucky and Texas, number M2020-001-SC-BAR-BP, BOPR number 2019-2987-0-AJ that states in pertinent part as follows. This matter is before the court upon a petition for discipline filed against attorney Cassidy Teeter on April 4th, 2019, upon a motion for default judgment and that charges in petition for discipline be deemed admitted filed on July 31st, 2019, upon an order for default judgment entered on August 15th, 2019, upon final hearing held on September 11th, 2019, upon findings of fact and conclusions of law entered on September 24th, 2019, upon service of the findings of fact and conclusions of law of the hearing panel on Ms. Teeter by the Executive Secretary of the Board on September 24th, 2019, upon the Board's application for assessment of costs filed September 24th, 2019, upon order granting application of assessment of costs entered on October 11th, 2019, upon service of the order granting application of assessment of costs upon Ms. Teeter on October 11th, 2019.
Ms. Kim, may I just interrupt for a second? Can you tell us what the discipline was in the foreign jurisdiction?
Yes, Your Honor. On September 25th of 2019, the Supreme Court of Tennessee had found that Ms. Teeter violated the rules of professional conduct 1.1, which was for competence, 1.3 for diligence, 1.4a, which is communication, 1.5 for fees, 1.16d, termination of representation, 3.2, expediting litigation, and 8.4a, misconduct. And that's all from the Tennessee Professional Rules of Conduct.
And what was the discipline that they imposed?
They disbarred her, or they ordered her to not practice law, which was the tantamount to disbarment, because she was never licensed to practice in Tennessee.
And so I should ask, what's the equivalent discipline in Texas that you're asking us to do or to impose?
We are requesting that she be disbarred as well.
Okay. And do you have evidence or exhibits at that point in support of that?
I do. Exhibit 1 is a certified copy of the order of enforcement entered on or about January 27, 2020 in the Supreme Court of Tennessee at Nashville in a matter styled In re Cassidy Teeter, an attorney licensed to practice law in Kentucky and Texas, number M2020-00101-SC-BAR-BP, BOPR number 2019-2987-0AJ. And then Exhibit 2 is a certified copy of the opinion and order issued by the Supreme Court of Kentucky, entered on or about February 20th of 2020 in the Supreme Court of Kentucky styled Kentucky Bar Association, movement, B. Cassidy Ann Teeter, respondent. Exhibit 3 is the original certificate from Blake A. Hawthorne, clerk of the Supreme Court of Texas, dated October 2nd, 2020, which indicates that the respondent is licensed and authorized to practice law in the state of Texas. The respondent currently resides in Nicholasville, Kentucky, and I would request that these exhibits be admitted.
I admit Exhibit 1 and 2. I don't have Exhibit 3 marked. I have a copy of it. It may be that I asked Ms. Truitt to mark the certificate from Blake A. Hawthorne. It's not designated in my materials as Exhibit 3, but I'll make sure that one is marked as Exhibit 3, and that will be offered. And from your offer, that'll be admitted as well.
Thank you, Your Honor.
You have anything further?
Yes, we are seeking disbarment as reciprocal discipline pursuant to Part 9 of the Texas Rules of Disciplinary Procedure.
Are there any questions from the board?
I know Ms. Kim discussed the discipline in Tennessee. Did you briefly also discuss the discipline that was imposed in Kentucky?
She was disbarred based off of the discipline that was imposed in Tennessee.
Is the order on the hearing panel that's referenced in Exhibit 1, is that available to the CDC? There's a reference in paragraph 2 of Exhibit 1 to an order of the hearing panel, and that the Supreme Court of Tennessee adopted the hearing panel's order as the court's order. Is that order available to the CDC?
That should be the order, Exhibit 1, the order of enforcement.
But there's an order referenced in the Supreme Court's opinion. It's on paragraph 2 of the Exhibit 1.
Paragraph 2 of Exhibit 1. That is something that we could get a hold of and then submit to the board.
That was you were mentioning the I didn't quite get where it was in the record of the disciplinary rules that were violated in Tennessee. Where is that in the record?
It's going to be part of Exhibit 2, the opinion and order issued by the Supreme Court of Kentucky.
Okay. Okay, so I see on page 3 of Exhibit 2, the Supreme Court of Tennessee is referencing that order that is not in the record. Is that right?
That is correct.
I got it. Okay, thank you.
Any other questions? Hearing none, the board will take this matter under advisement. Ms. Kim, thank you very much. Ms. Truitt, do you know if Mr. Davison is in the waiting room yet?
He is. I'll admit him now.
Perfect. And Ms. Kim, I believe you have a witness.
Yes, Your Honor. We have Heather White from our office. She's part of our compliance team.
Perfect. Let me call the case for a second and then I'll make sure to swear her under oath. At this time, the board will call In Re Ward BB Davison, BODA cause number 64755. Mr. Davison, this is an evidentiary proceeding to determine whether or not you have violated one or more terms of your probation. The Office of Chief Disciplinary Counsel must prove by a preponderance of the evidence that you materially violated one or more terms or conditions of your probation. Does either side wish to make a brief opening statement?
Yes, I would like to.
Okay.
Go ahead, Ms. Kim.
Ms. Kim, you may proceed.
Jenny Kim for the commission. May it please the board. This is a revocation of probation proceeding under Part 2.22 of the Texas Rules of Disciplinary Procedure, seeking to revoke a 12-month agreed partially probated suspension, with the active suspension beginning on December 1st of 2019 and ending on December 31st of 2019, and the probated suspension beginning on January 1st of 2020 and set to end on November 30th, 2020. Mr. Davison has shown by preponderance of the evidence that he has failed to comply with terms set forth in the agreed judgment that he signed, and we would request that his probation be revoked.
Thank you. Mr. Davison, you may proceed.
Yes, my name is Ward Davison. I'm the respondent here. A couple of things. One, I'd stipulate to admit all the evidence that's been submitted by Ms. Kim. Two, I agree that I have violated some of the conditions that I agreed to. And three, the only thing I'm requesting here today is an extension of time to fulfill those commitments, considering I've had difficulty generating income over the COVID thing and that kind of stuff. So, and that's it. And also I apologize for not fulfilling those commitments and bringing everybody in here on Friday morning. Thank you.
Thank you, Mr. Davison. Ms. Kim, you may proceed.
The petition for revocation of probation was filed with the Board of Disciplinary Appeals on September 24th of 2020. The respondent was personally served on October 5th, 2020 with the petition and notice of remote hearing by Stephanie Sizemore, a private process server. Original proof of service was filed on October 19th, 2020. The terms of the judgment that the respondent violated included surrendering his law license within 10 days of his receipt of a copy of the judgment, scheduling a full psychological assessment to be conducted by a mental health professional licensed in Texas, such as a psychiatrist, psychologist, a master's level social worker, or a licensed professional.
We did both openings. If this is an evidentiary hearing, I'll have you call your first witness to be able to put on evidence in support of your petition.
Yes, Your Honor. At this time, I would like to call Heather White.
Okay, would you please bring Ms. White into the main room and I'll swear her in.
She's not on. I think she's not in a waiting room. Can someone ask her to join us?
Yes, I'll let her know.
She's on now. Just a second.
Thank you, Ms. Truitt. Good morning, Ms. White. Can you hear me?
Yes, I can.
Would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you will give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Ms. Kim, you may proceed.
Could you please state your full name for the board?
Yes, my name is Heather Kathleen White.
And who do you work for?
I work for the State Bar of Texas, Office of the Chief Disciplinary Counsel.
How long?
I've been employed for the State Bar since June 2012.
And what is your current position with the State Bar?
I am the statewide compliance monitor for the Office of the Chief Disciplinary Counsel.
And how long have you been employed in this position?
Since September 2017.
And what are your duties as compliance monitor?
I monitor related to disciplinary sanctions that have been imposed against attorneys in order to determine whether they've complied with their judgment terms.
Are you familiar with case numbers 2018-06874, 2018-07041, styled in the matter of Ward B.B. Davison, bar number 24066-787?
Yes, I am.
Do you monitor that judgment file?
I do.
I'd like to ask you to look at a copy of Exhibit 1, which was sent to you.
I have it.
And do you recognize this document?
Yes, I do.
What is this document?
This is an agreed judgment of partially prohibited suspension, case number 2018-06874, 2018-07041, in the matter of Ward B.B. Davison, State Bar number 2466787.
And when was this document signed?
It was signed November 27, 2019.
And this document was already previously admitted. And I wanted to discuss what the terms of the judgment were in this document.
Actually, I don't have that admitted yet. If you'd like to offer that, but I don't have any exhibits that are admitted yet.
Oh, yes, Your Honor. If I'd like to go ahead and offer Exhibit 1.
Mr. Davison, in your response?
No objection.
Exhibit number 1 is admitted.
I believe Mr. Davidson indicated earlier that he was agreeable to all the exhibits being admitted into evidence.
I heard the same. If the CDC wants to introduce all of those, then we can do so now.
Yes, Your Honor, I would like to go ahead. Would you prefer I introduce them all at one time or just piece by piece?
No, it'd certainly be more efficient. I'll let you prove your case however you'd like. But at that point, if there's an indication from opposing counsel that he has no objections to 1 through 10, then if you offer 1 through 10, I'll allow him to do so on the record.
Okay. At this time, I would like to offer the following exhibits. Petitioner's Exhibit 1, prior discipline, agreed judgment of partially probated suspension, signed November 27th, 2019. Petitioner's Exhibit 2, prior discipline, agreed judgment of private reprimand, signed November 27th of 2018. Petitioner's Exhibit 3, letter from the State Bar Compliance to Ward Davison, dated January 13th, 2020, regarding case number 2018-06874, Commission for Lawyer Discipline versus Ward Bennett Davison. Petitioner's Exhibit 4, email from the State Bar Compliance to Ward Davison, dated March 2nd, 2020, subject case number 2018-606874 and 2018-07041, CFLD versus Ward Davison. Petitioner's Exhibit 5, email and letter from the State Bar Compliance to Ward Davison dated March 5th, 2020, regarding case number 2018-06874 and 2018-07041, Commission for Lawyer Discipline versus Ward Bennett Davison. Petitioner's Exhibit 6, email and letter from the State Bar Compliance to Ward Davison dated April 27th, 2020, regarding case number 2018-06874 and 07041, Commission for Lawyer Discipline versus Ward Brackett Bennett Davison. Petitioners Exhibit 7, email from the State Bar Compliance to Ward Davison dated May 26, 2020, subject out of compliance 2018-06874, 2018-07041. Petitioners Exhibit 8, emails between State Bar Compliance and Ward Davison from May 27, 2020 to June 22, 2020, subject regarding 2018-06874, CFLD versus Ward Davison. Petitioners Exhibit 9, emails between State Bar Compliance and Ward Davison from July 2nd, 2020 to August 11, 2020. Subject regarding Ward Davison is unavailable regarding 2018-06874, CFLD versus Ward Davison. And Petitioners Exhibit 10, a certificate of Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated October 19th, 2020.
Mr. Davison, I believe you said in opening statements that you had no objections, but I'll ask you formally now. Do you have any objections to exhibits 1 through 10?
No objections, Your Honor.
Exhibits 1 through 10 shall be admitted.
Thank you, Your Honor. Ms. White, what were the terms of the judgment in Exhibit 1?
Yes, Mr. Davison was required to contact the compliance team within 7 days of receipt of the judgment. He was required to submit an affidavit stating that he notified all current clients and opposing counsel in writing of his active suspension, as well as return any papers, documents, files, unearned fees to said clients or to an attorney of their choosing. He was required to submit an affidavit stating that he notified all judges and courts in writing of the terms of his suspension where he had any pending matters. He was required to surrender his law license and state bar card. He was supposed to contact TLAP within 10 days of receipt of the judgment and then submit verification of that contact within 15 days. He was required to engage the services of a mental health provider within 10 days of receipt of the judgment and submit to a mental health evaluation within 60 days of receipt of the judgment. And then if recommended by the treatment plan, he was to continue to submit quarterly reports from that mental health provider. He was also required to submit law practice to monitoring by a law practice monitor for the duration of his probated suspension. And he was required to pay restitution in the amount of $1,000 to Ms. Alessandra Kate and $2,500 in restitution to Ms. Fanny Gooten and $500 to the State Bar of Texas for attorney's fees.
And what terms of the judgment did Mr. Davison fail to timely comply with?
I'm not sure if I mentioned that he was supposed to surrender his law license and state bar card, but he was supposed to do that too. He did not surrender his law license or an affidavit stating that he could not locate his law license. He did not timely submit his mental health evaluation. We did receive it in September, but we didn't receive any continued reports from the mental health provider. He did not submit his law practice to a monitoring by a law practice monitor. We did not receive the $2,500 for Ms. Fanny Gooten or the remaining amount owed to Ms. Alessandra Kate in the amount of $500 or the $500 in attorney's fees to the State Bar.
What communications did you have with Mr. Davison regarding his compliance?
We tried to reach out to Mr. Davison several times throughout the months of January and August of this year. We sent him several emails and letters. I also called and left messages on his work phone and his cell phone on March 4th of this year. And then I successfully talked to Mr. Davison on May 27th of this year.
And when was the first time you heard from Mr. Davison?
It was May 27th of 2020.
If you could please look at Petitioner's Exhibit 3.
3, yes.
And if you could please ID this.
Yes, this is a letter that was sent to Mr. Davison.
And you recognize this document?
I do.
Okay. And when was this letter sent?
January 13th, 2020,
And how was it sent?
via certified mail.
And what address was it sent to?
1201 North Riverfront Boulevard, Suite 150, Dallas, Texas 75207.
And whose address was that?
Mr. Davison's work address.
Would you please tell the board what you told Mr. Davison in this letter regarding case number 2018-06874?
Yes, this letter, Mr. Davison's, excuse me, active suspension was ending and that he was being returned to active membership roles. But I also reminded him that he was not in compliance with his judgment terms and that he was required to contact the compliance team to discuss the compliance with his judgment terms, and also to surrender his law license and state bar card, submit proof that he contacted TLAP, and to schedule an assessment with the mental health provider, then continue to submit quarterly reports if recommended in the treatment plan, and then he also needed to contact our special programs administrator to coordinate compliance for the practice monitor term.
And just so we're clear, this letter you reference case number 2018-06874. Are you using that as an abbreviated reference to the judgment that also included case number 2018-07041?
That is correct.
Okay. And did he timely submit those items to you?
He did not.
And I'm going to ask you to take a look at Petitioner's Exhibit 4.
Okay.
Do you recognize this document?
Yes, I do.
If you could please ID it for the board.
Yes, this is an email that was sent to Mr. Davison by my assistant, and I was also copied on the email.
And what email address was it sent to?
ward@warddavisonlaw.com.
And whose email address is that?
Mr. Davison's.
Okay. And have these documents been altered in any way?
No, they have not.
Okay. What is the date of the email?
March 2nd, 2020.
And what was Mr. Davison told in this email?
Mr. Davison was reminded that his payment for restitution and attorney's fees were due. My assistant laid out how much was due. It was $500 in attorney's fees and then $2,500 to Ms. Gooten and $1,000 to Ms. Kate. And she also provided him all the mailing instructions.
And did he timely submit those payments to you?
No, he did not.
And if you could please take a look at Petitioner's Exhibit 5.
Okay,
Do you recognize this document?
I do.
If you could please ID it for the board.
Yes, this is a letter, or sorry, an email and a letter sent to Mr. Davison.
And what address was the letter sent to?
His work address, the 1201 Riverfront Boulevard, Suite 150.
Okay. And how was it sent?
It was sent via regular mail and certified mail, and then it was also emailed to him.
And what's the date of the letter and the email?
March 5th, 2020.
And are both those documents dated March 5th, 2020?
Yes.
And have these documents been altered in any way?
No, they have not.
What was Mr. Davison told in this letter regarding judgment for case number 2018-06874 and 2018-07041?
I told Mr. Davison that he was not in compliance with this judgment and that he needed to contact our office immediately, and that he was to submit all past due items within 10 days of receipt of this letter, and also that further discipline may occur due to his non-compliance.
And did he timely submit any items to you?
And no, he did not.
Okay. If you could please take a look at Petitioner's Exhibit 6.
Okay.
Do you recognize this document?
Yes, I do.
If you could please ID it for the board.
Yes, this is an email sent by my assistant to Mr. Davison.
And have those documents been altered in any way?
No.
What's the date of the email?
April 27th, 2020.
And what email address was it sent to?
ward@warddavisonlaw.com.
And what did you tell Mr. Davison in this email?
I told him in the attached letter in the email that our records indicated he was not in compliance, and that the State Bar of Texas understands that the current COVID-19 emergency may be having an adverse effect on him, but that we needed him to contact us within 30 days. And I also reminded him again that additional discipline may occur due to his non-compliance.
Did he immediately contact the compliance team?
No, not immediately.
If you could take a look at Petitioner's Exhibit 7.
Okay,
Do you recognize this document?
I do.
And if you could please ID it for the board.
Yes, this is an email I sent to Mr. Davison.
And have those documents been altered in any way?
No,
What's the date of the email?
May 26, 2020,
What email address was it sent to?
ward@warddavisonlaw.com.
And what did you tell Mr. Davison in this email?
I told him again that he was not in compliance with the above referenced judgment and that he needed to submit the following items. Those items included his law license and state bar card. He needed to contact the compliance team, submit his psych eval or any subsequent reports, and to pay restitution and attorney's fees.
When was Mr. Davison supposed to submit his law license and bar card?
December 1st, 2019.
And when was Mr. Davison supposed to submit his psych evaluation and any subsequent reports?
The psych evaluation was due within 60 days of receipt of the judgment, and the subsequent reports were to begin 90 days after receipt of the judgment, if that was recommended in his treatment plan.
Okay. And when was Mr. Davison supposed to pay restitution and attorney's fees?
March 1st, 2020.
If you could take a look at Petitioner's Exhibit 8.
Okay,
Do you recognize this document?
I do.
If you could ID it for the board, please.
Yes, this is an email that I sent.
And have these documents been altered in any way?
No,
What's the date of the email on page 4 of the exhibit?
May 27, 2020.
What email address was it sent to?
ward@warddavisonlaw.com.
And in this email, what did you tell Mr. Davison?
This email solidified a phone conversation that I had with Mr. Davison earlier in the day. This was the first time I had talked to Mr. Davison. We discussed all of his compliance items, including submitting his law license and state bar card, to which he stated he was not in possession of those. So I told him he needed to file an affidavit stating that he needed to submit his proof of contact with TLAP. He said he already contacted TLAP, but he had not submitted the proof, and that he needed to submit his mental health assessment and any continuing mental health reports. He needed to submit to monitoring of his law practice. And he also needed to submit his payments for restitution and attorney's fees, to which he had agreed to a payment plan of $500 a month beginning June 15th, 2020, and until paid in full.
And approximately how long after the date the judgment was signed did he contact you?
It had been about 6 months.
And did Mr. Davison fully comply with what you had laid out?
No, he had not.
What did Mr. Davison fail to do?
He failed to submit his law license or an affidavit stating he wasn't in possession with it. He failed to timely submit his mental health assessment. We did receive it on September 7th, but we didn't receive any continuing reports from his mental health provider. He did not submit to the monitoring of law practice by a law practice monitor. We received one payment for restitution for Ms. Alessandra Kate in the amount of $500, but it's still an additional $500. We received no payments for Ms. Fanny Gooten, and we did not receive payment for attorney's fees.
And if you could take a look at Petitioner's Exhibit 9. Do you recognize this document?
I do.
If you could please ID it for the board.
This is an email I sent to Mr. Davison dated July 9th, 2020.
And has this document been altered in any way?
No.
And what is the date of the email on page 2 of the exhibit?
July 9th, 2020.
And what email address was it sent to?
ward@warddavissonlaw.com.
What did you tell Mr. Davison in this email regarding his judgment?
I confirmed that we had received the payment from Kate, and also confirmed that we received his confirmation and an affidavit stating that he was not in possession of his state bar card. I reminded him that I needed a subsequent affidavit regarding his law license or the actual law license. And I also asked him about his mental health assessment and if he could provide me when he was going to be submitting, or information when he was going to be submitting his next payment for Ms. Kate.
Did Mr. Davison timely respond to your email?
No, he did not.
Did Mr. Davison submit any of the missing items?
No, he did not.
What did you do?
Not at that point, he did not.
What did you do?
Well, he eventually submitted his mental health assessment in September.
Okay. And
sorry, go ahead.
And so when was the last time you heard from Mr. Davison?
Well, I emailed him again on August 7th, asking him or telling him that I never received a response from my July 9th email, and if he could please provide me a status update on the payment, psych assessment, and the affidavit as soon as possible. And then he did respond to me on August 11th, and he just said, "Will do."
And how did you respond to Mr. Davison's email?
I sent him a follow-up email on August 11th, and I said, "Can you please tell me when you're going to submit these items, and did he have a time frame?"
And did Mr. Davison submit any of those missing items?
No, he did not.
And just
aside from the mental health evaluation. I'm sorry. We did receive his mental health evaluation.
And when did you receive his mental health evaluation?
I received his mental health evaluation on September 8th, 2020.
And had you heard from Mr. Davison since?
No.
And did he submit any of the other missing items?
No, we have not received anything else, including payments.
And if you could reiterate to the board what terms of the judgment Mr. Davison is out of compliance with?
Yes, we still need an affidavit stating that he is not in possession of his law license or his actual law license. We still need his quarterly reports from his mental health provider. We still need reports regarding his law practice monitor. And we also need the remaining $500 owed to Ms. Kate, $500 owed to Ms. Gooten, and $500 owed in attorney's fees.
And could you repeat the amount that's owed to Ms. Gooten?
Yes, $2,500.
Ask the witness.
Mr. Davison?
Good morning, Ms. White.
Good morning.
First off, just thank you for being so professional and helping me with this. I only have one question. Did the health provider state that I needed to continue treatment?
Yes.
Okay, that's it. Thank you.
You're welcome. Thank you.
Ms. Kim?
Nothing further.
I'll direct this to the board. Does the board have any questions of the witness?
I have a question. Ms. White, among the requirements of the suspension were that Mr. Davison notify judges and clients of the suspension and to provide an affidavit to that effect. Did he provide that information to your office?
He did. We timely received affidavits regarding courts and clients.
Okay, thank you.
You're welcome.
Ms. White, when you were mentioning your interactions with Mr. Davison, I mean, was there any reason for you to suspect for any delay in him actually corresponding with you regarding specific items? Were they just part of the course? Did you find any issues whatsoever in those communications? Because I see that they ebbed and flowed in and out.
Right. I'm not really sure what was going on with Mr. Davison at the time. I do know he when I did talk to him, he did seem very eager to get into compliance, and then I'm not sure what happened after that.
Any other questions from the board? Ms. Kim, Mr. Davison, any questions you want to ask the witness in response to the questions from the board?
No, Your Honor.
No, Your Honor.
Thank you, Ms. White.
Thank you.
Ms. Kim, you may call your next witness.
I have no other witnesses, Your Honor.
Does the commission rest?
Yes, Your Honor, we rest.
Mr. Davison, you may proceed. And as it appears you're representing yourself, if there's anything that you wish to say, I need to swear you in as a witness as I would with any other. If you can raise your right hand. Do you solemnly swear or affirm under penalty of perjury the testimony you will give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
Okay. Well, I certainly didn't, make my timely payments, or I haven't even, finished making them. I don't dispute that they're supposed to be made. It's just been, a rough time even collecting from the clients I do have right now. As far as the mental health assessment, I have been seeing, I began seeing someone suggested by TLAP before the order was even signed. I've continued to see him over FaceTime after the COVID thing settled down. And in fact, I saw him just the other day. I do not have my law license. I should have provided an affidavit at Ms. White's request to that effect. I believed I had done it when I sent in the one with the bar card. As far as the mentor, it was tough finding a mentor. I wasn't sure how to go about it. I did ask Ms. White how to go about it, and she sent me a list of people that I should be trying to get in touch with. Other than that, that's the only defense, and I don't know. It certainly doesn't cover the mentor or the money. I don't know if this is the appropriate time, Your Honor, to kind of to make a type of closing statement or to talk about punishment. If not, then I rest. But if it is, then I'll continue.
Why don't we just keep the first part of your presentation related to the evidence in response to the ACDC here, because one of the things I want to remind you is I think you've sent the board an exhibit, but that has not been introduced. And so if that's something just that you want to have us consider, please offer that.
No, I believe Ms. White addressed it in her testimony, so I don't need to enter it.
Okay. Second, I will defer to the board, but we don't have bifurcated proceedings. So if there's additional information that you wish to present via testimony, you should do so now, because at that point, once both sides rest and close, we'll take the case under advisement. So there won't be a second time for you to be able to address with other testimony of what you're seeking.
Thank you, Judge. Yeah, I entered into this agreement with the best of intentions. It was in December of 2019. Several things have happened since then, along with disease that have affected my personal responsibilities with older members of my family and very young members of my family. It really hurt my clients and their ability to pay. I'm owed over $14,000 by clients. I'm not taking them to court or anything, but that is obviously affecting my ability to pay. I'm currently looking for work outside of legal work and have some interviews lined up for next week. And I'm also looking at selling certain assets to come into compliance. I do want to come into compliance. I would like to offer some type of arrangement whereby I could, come into compliance with the affidavit, the reports from my therapist, who's recommended by TLAP, and find a mentor all by next week, and finalize payments by January 31st. And I don't know if it's available, but a creative solution might be, I would certainly be willing to sign an agreed order that my license be revoked for 18 months if I don't come into compliance by that time. So, I understand the severity of my actions, and that restitution needs to be made. Revoking my license at this time will hinder my ability to make that restitution. It'll hurt that ability. So that, I guess that's my final thing is if we could agree, what I'd like to do is have the payments done by January 31st, everything else done by next week. And I would certainly sign an order that if that wasn't met, that it's an automatic 18-month suspension on February 1. And that's all I have to say, unless you have any questions.
Ms. Kim.
Yes, Your Honor. Mr. Davison, how long did you have to come into compliance from the date the judgment was signed?
We're looking at 10 and a half months.
And in the communications that you had with Ms. White or with the State Bar Compliance Office, did you ever indicate that you needed additional help or assistance?
I believe we discussed that. Yes, ma'am.
And in what way do you believe you discussed it?
We discussed the fact that, money had become an issue, and that's why we talked about the payment plan. I think that's the main point of it.
And when was it that you discussed the payment plan with Ms. White?
Over the summer.
And how long had that been after the funds were due or the restitution was due?
I believe 2 months almost.
And was there anything preventing you from contacting the State Bar Compliance team sooner than when you did?
No, I had full access to my phone and email. No, ma'am.
And did you comply with the terms of the payment plan that you set forth with Ms. White?
No, I could not. I was not able to.
And what makes you believe that you'll be able to comply with the terms now?
Well, I've been continuing to work. So I do have more payments coming due, and I have promises from my clients that they will pay. And also because I'll do anything to get into compliance. Like I said, I'm already looking at selling certain, physical assets that will cover the amount. It's unfortunate that it's such a small amount and that I may lose my license over it, but it's also fortunate in that it's something that I can tackle. And, I didn't think we were going to be in front of this board until I got that letter that we were going to be in front of this board.
Did Ms. White or the compliance team not tell you the repercussions of failing to comply with the terms of your judgment?
She did. No, she did.
And about when would you say that they started telling you what would happen and the repercussions of not failing to comply with the terms of the judgment?
Continuously over the last year.
And was there anything preventing you from contacting an attorney monitor to monitor your practice as agreed to in the judgment?
I couldn't afford to pay one. And the other thing is you can't have ties to them that where it could be suspect if they would be on it, like they can't be your friends. So that was the only thing that was preventing me from reaching out.
And did you ever tell the compliance team that you had these problems?
I believe we wrote it in an email. I believe I wrote it in an email, but not, it wasn't an ongoing discussion.
And was there anything preventing you from making this an ongoing discussion?
No, ma'am. And I'm not trying to push anything back on TLAP. I mean, they've been very gracious with me, you know, going through this time. I'm here because of my inaction. I understand that. So I'm not trying to say it's anybody else's fault.
Nothing further, Your Honor.
I'll now ask the board if the board has any questions of the witness.
Davidson, Joe Cleveland, you mentioned that you had some assets that were available to sell. What are those assets?
Firearms and a car.
What is the value of the firearms that you have equity in to sell and get the money to pay for the assessments, the restitution?
I'm not sure about the firearms, but the car, you know, it's they're paid off, so I'll have plenty of I should have plenty of equity there.
What's the value of the vehicle?
$6,000 that I'm thinking of. That's what I think it is. It's, you know, what I can sell it for.
Thinking of, or is it the Blue Book value?
Sure.
Thinking of, or is that the Blue Book value?
That's the Blue Book value for its condition.
You had made mention, and first of all, I do want to say I do appreciate you taking responsibility and saying specifically that what the you know, CDC and all of them have worked with you regarding this. That I do appreciate. I am a little concerned about some of the things you did say, though. For example, when you're talking about TLAP, when you said that you met with them the other day, how consistent have you been with that counseling?
So I didn't meet with TLAP the other day. TLAP had provided me with some names, and I've been meeting with Dr. Bill Edwards. We began, I believe, in September. We began right around the time that we had the initial hearing for this issue. And I was seeing him every week for a while. And then during the holidays of that year, we went to every other week, and we maintained that, except for some drop off around COVID for about 5 or 6 weeks. And then we got back on every other week, and we figured out a way to do FaceTime. He's an older gentleman, so we couldn't do one-on-ones. And we've been continuing to do that. I think we moved it to month about 2 months ago. My next meeting with him is a month from yesterday. So in 29 days.
You had made mention that, and I don't want to go into too much personal details regarding that, but you said that you had some personal responsibility regarding older and younger members of your family. Was that related to COVID-19? I was trying to understand that. And you said that's impacted your ability to comply.
Yes, my you know, I was raised by a single mother. She's advanced and she has not aged well. And she already had pneumonia-like symptoms at that time, and had some neck surgeries. And so I was actively taking care of her. And then we have, at the time, he was one and a half. And so any type of daycare that we had for him was gone. So, you know, I had to take on that as well. And we've since settled it over the summer. We found something for him, which has been really good for our whole family. And also my mother's on some new medication as of about a month ago. So she's doing much better. Does that answer your question?
Yeah, I think so. How many members of your family do you have that you're caring for?
Well, my mother, my son, and my wife, although she probably takes care of me as much as I take care of her. So I don't know if that counts.
Thank you.
Mr. Davidson, you talked about the difficulties in complying with the monetary components of your suspension, but what's your explanation for some of the non-monetary failures, like failing to contact TLAP within 15 days of the judgment, failing to submit quarterly reports, those type of issues?
Well, with the TLAP, I had contacted them before the order even came through. But I don't think what I was missing is I didn't provide proof of that to Ms. White's division. And there was some disconnect too, because I thought that everybody was talking together and they weren't. So some of that might be excused by that. As far as Ms. White's asking me for an affidavit on the license, that would have been a simple thing to send in, and I should have done that. And as far as the monitoring with another attorney, maybe at the time I was feeling like I wasn't supported, but at the end of the day, that was not her job. I needed to find that monitor. And I think those are those types of issues. So some of them can be explained, but not all of them, certainly.
Thank you.
Yes, ma'am.
Are there any other questions from the board?
I heard someone talking, but I didn't see anybody's.
Hearing none. Ms. Kim, any recross?
You had said that you had made efforts to contact TLAP and you did that before the judgment was even signed, but you hadn't gotten that information to our office.
Correct.
When was the judgment signed?
I believe in November. I believe late November. It's in evidence, but November 27th, 2019.
And when was the first time you contacted our office?
The CD, the disciplinary office, probably whenever Miss White says so. I don't remember the date, but.
Okay, so you wouldn't disagree with the statement that our office has been trying to get in contact with you since January of 2020?
I would not disagree with that statement.
And that you had contacted our office in May of 2020?
I would not disagree with that.
Nothing further, Your Honor.
Mr. Davison, do you have any further testimony?
No, Your Honor.
And do you have any, and I'm not an honor, I'm just
sorry, just so used to it. No, sir.
Just a board member. Do you have any further exhibits or anything else you wish to offer in your case in chief?
No, and thank you for hearing me out.
And do you rest?
Yes, I do.
All right. Ms. Kim, Ms. Davison, before the board retires to deliberate, do you have any final arguments you wish to say? And I might suggest that what typically helps us during deliberations is if each of you would articulate what you are asking us to do and why.
Yes, Your Honor. So the exhibits that we provided show that the compliance team continuously reached out to Mr. Davison, that he didn't detail any difficulties in those discussions that he had with the compliance team, and that it took respondent months after the date that certain items were due to come into compliance with them. And we don't expect that that will change, that behavior will change. So we are seeking entry of a judgment, revoking probation, and actively suspending the respondent from the practice of law for 12 months.
Let me clarify, for 12 months starting upon the date that the order is signed?
Yes, Your Honor.
Mr. Davidson.
Yes. Well, I didn't come into full compliance. I did comply as best I could. What I'm asking the court to do is to enter an agreement that allows me to make full restitution, come to complete compliance. And if I fail to do so at that point, suspend an active suspension for 18 months. In the alternative, I would request that if the court does decide to actively suspend me at this time, that I be given a month, at least 30 days, in order to wrap up any legal affairs with current clients and things like that before the suspension begins.
Mr. Davison, Kim, thank you very much for your assistance in this matter this morning and for your advocacy. We very much appreciate it. At this point, proceedings are adjourned, and we will now be adjourned to consider the evidence and the testimony presented in this case.
Thank you, Your Honor.
And that concludes our docket this morning. Thank you very much. Ms. Seibert, we can go off the record.
Off the record at 10:10 a.m.
All right, friends, I believe we log out and then there's a separate link that we can log into for deliberation.